we begin with the topic, and you guys know what the topic is, I hope, today. So, Sushila Ram Varma, 25 plus years of experience in various types of laws and expertise in business and commercial law. She has been working in advisory, transactional work, negotiations, court practice, management of litigation, arbitration, domestic and international arbitration, etc. She has worked with well-known international organizations, which include Bechtel International, Earn Oil and Gas International, Sony, uh, United Airlines, and the list goes on, Benedict Hospitality Management School, and so on. She's also worked with prominent Indian clients, including Tata Group, Premier Group, Hindustan Times, and Bank of Baroda. And again, the list goes on. She's a member of various international and national associations for rendering advice to clients from various countries for both inbound and outbound commercial transactions. Membership of national organizations includes she's a member of Supreme Court Bar Association, Delhi High Court Bar Association, the Andhra Pradesh High Court Association, Advocates Association, the Federation of Telangana Chambers of Commerce. When it comes to international association, she is part of the Indo-American Chambers of Commerce, Vittal and Partners, Cross Border Associates, All Ladies League, the Confederation of Indian Industry. So, in addition, she is also the president of an NGO called the Child Foundation that has been initiated to work for poor children in different walks of life. Again, there is so much to talk about her, but one major aspect before closing her introduction, I would like to state that she's founder and chief consultant of the Indian Lawyer and Allied Services, a multi-city business and commercial boutique law firm having a pan-India presence with offices in Delhi, Mumbai, Hyderabad, Chennai, Darjeeling. The firm has handled a wide range of clients, beginning from startups, business houses, multi-billion-dollar companies to high net worth individuals. The firm's policy is to be reliable, responsible, and resourceful. And I think that she is the best possible candidate for discussion today. That is an introduction on legal research. Of course, there is going to be more than just an introduction on legal research. We do not want to limit the idea of legal research to university projects or memos for you guys. We want the students to ponder upon open questions about real life research when it comes to your openings in the legal field itself and the profession of legal. We want you to understand how the theory of legal research should be additional to the practical, rather than a mere outburst of theoretical in the practical world. We want you guys to understand how you can utilize the theoretical practice of legal research writing into the practical world, into your profession as legal professionals. Sushila ma'am, we are going to begin with our first question today so that we can continue on our interactive question and answer session further.
Purnima, before you start, I would just like to introduce a small fact. I'm actually feeling very privileged that I'm getting a chance to address so many young lawyers and students. I remember the days when we first stepped into the profession. The difference between the theoretical world and the practical world is so huge that one cannot believe that there is such a huge gap until and unless one actually comes to the practical side. I remember those days when we didn't know how to research, we didn't know how to read a file, we didn't know how to prepare for arguments, and probably the scariest part was when we had to do our first maiden court appearance. So, over the years, by and by, we learned. So I just wanted to give hope to everybody that there is nothing to feel worried about. It's your turn now to understand and learn the ropes, and you will learn because all of us did that. In fact, I'm grateful to all those people who took out the time and patience to actually guide us through and through. And I feel today it's our turn to now pay back to society what society gave us. And as a result, I feel I'm honored to be doing this program and helping young lawyers and students to learn the ropes. Okay, Purnima, let's start.
Right. So we will begin with the most basic questions because uh, we'll start with the introduction and then let's go into details. So Sushila ma'am, according to you, what is synopsis when it comes to legal research and why is it so important?
Well, Purnima, to put it very simplistically, a synopsis is a gist of the entire case. Now, when we say case, it could be anything. You could be preparing for an advisory, you could be preparing to draft a transactional document, or you could be getting ready for a court matter or even an arbitration. It doesn't matter what it is. So, synopsis is generally a gist of the case. But I must advise everybody that a synopsis may be a gist of just the facts, and you may use it as a reference point to do your research, but never, and I would say never, start your research on the basis of only a synopsis. I always advise my team that as and when you have to start working on any new matter, first and foremost, list out all the documents that you have, make a very detailed list of dates and events. It doesn't matter if some events seem very meaningless, because what happens in law is every time you read a document afresh, a new idea strikes you. So I personally feel that right at the inception, you should put in as much details as the documents allow you to, make a comprehensive list of dates, and then once that is done, certain ideas will flow into your mind. Also bear in mind what is it exactly that the client wants. Keep that as a focus point and then start your research.
Right. So okay, as we have been talking about the so how to begin with a brief, but what do you think that is the purpose of legal research, and how is it that we can make it more useful?
Well, the purpose of legal research obviously is see, as a lawyer, the research is probably the most important part of being a lawyer. If you know your facts thoroughly and then you know your law thoroughly, there is nothing that will stop you from arguing your case if it's a court matter, because a little knowledge is always a dangerous thing. So once you are prepared with the entire matter thoroughly, you can argue anywhere. You could probably even talk at the United Nations. Nothing would, prevent you from being confident. So ultimately, everything boils down to only one simple fact, and that is you must be thorough in whatever you do. So the purpose of legal research, obviously, the first one would be culling out propositions in fact, and thereafter making out propositions in law. Then you have to keep looking at the reading and rereading the documents to see whether there are any new facts that come out of your second read or your third read. Then you analyze the facts and then try and see how it is applied to your theoretical knowledge. Then after that, start doing the research. Now, research, I must say, must be done in a very planned manner. You don't just go rushing off to, but now suppose you're doing a research of case law. You don't go rushing off to 2020. You must start at the beginning. If you start at the beginning, you will understand that law, which is very dynamic, keeps changing with the passage of time. So a concept may have been interpreted in 1960 in a particular manner, but as you go over the years, you will see there are certain developments that have come about.
Sorry for the interruption.
Yes.
Ma'am,
Yes.
I'm sorry for the interruption.
Tell me.
I guess your YouTube video is on. If you can just pause it or mute it.
What do I have to do? It
Just
says
pause
live.
just mute your YouTube video.
But I don't know how to do that. Sahil, I don't know how to do that. It says view stream on YouTube, copy streaming link. And there's a recording. Sahil, there's a live option also near YouTube. The participants are saying it's audible.
Ma'am, you must have opened YouTube on different tab.
Oh, okay, let me just check. No, Sahil, it's not opened. I've shut all my tabs. Let me just check once.
Now it is. Okay, so we can.
All right.
Okay, so Sushila, we were talking about the purpose, and you were talking to us about all these aspects that we need to keep in mind when it comes to doing legal research and what it really takes to begin doing legal research. So
Yes. So I was talking about, yes, I was talking about how you should go about your legal research, that you should do it in a chronological manner so that you understand that law is, which is a very dynamic subject, so that you understand how it has grown over the years and how what was interpreted in 1960 may not necessarily be interpreted in the same manner in 2020. Similarly, even when it comes to textbooks, you should always look at authorities first and understand the basic concept, and only after that you should continue your research or in a chronological manner.
right. So because we are talking about what aspects to actually look into and how you should be using it chronologically. The next question is very evident. What are the sources and what is the chronology of the sources? We are always talking about primary sources, maybe secondary sources. But what are these sources and how can we use them for legal research?
Well, in legal research, I would say there are just two sources. One is the primary source and one is the secondary source. Now, when you say primary source, you're talking about things like the Constitution of India, or you're talking about the bare acts in which the law has been set out, or you're talking about notifications or orders of the government. But when it comes to research, you have to look at the secondary sources, which actually explain what the primary source of law is. So you will have to look at textbooks in which the authors have been able to explain the concepts of the law. You will have to go through case laws. You will have to go through articles. You might even have to go through some blogs and other related topics that would help you to understand the primary source of law. So ultimately, what happens is in the beginning, your concept of law is very theoretical. You do not understand many aspects. So it is always better to go back to authors who are authorities on the subject and try and understand what they have understood of the primary source, and thereafter make your conclusion and start your research.
Okay, so all right, we are talking about all these sources. It might be textbooks, it might be encyclopedias, etc. What do you think are the most important qualities? We've talked about legal research, but according to your experience, for a good legal research assistant, what are the qualities that they need to look out for themselves when it comes to beginning the research?
I would say law is a profession that demands a lot of discipline. So the first and primary thing that you would have to, quality that you would have to have is discipline. Another thing is that you would have to be very organized. Now, discipline and being organized can be used interchangeably, because only if you're disciplined that you will be able to get yourself organized, and you will be able to set out a pattern as to how to go about the research. Another very important thing is you must ensure that there are no distractions. I noticed that youngsters today have too many distractions. You have your WhatsApp, you have your Facebook, you have your messages, and I don't know what not. So these things should never distract you, because law is a very difficult subject to practice. It is not easy. If you lose your focus, obviously you're going to make mistakes. Apart from that, you also have to have good communication skills, which is both written and oral. You also have to have a reasonable amount of computer skills, because today nobody can manage without knowing how to operate a computer system. Many of your research tools are actually digital, so you definitely need to have knowledge in this area. And most importantly, I think you need to have an eye for detail. You should read everything very patiently and carefully.
Right. So, Sushila ma'am, we were talking about this, when we were discussing about it, we were talking about the idea of this, the strength to proofread. You need to proofread things again and again. So, what do you think that this is, how does proofread help with this aspect? Because I think this is one of the most important things when it comes, proofreading itself comes from the idea of legal profession.
Yes, I completely agree with you on the proofreading. I have always told my team members that a legal document is for posterity. So if you have made a mistake and you have not proofread it carefully, there is bound, I mean, that mistake will carry on forever. So proofreading is probably one of the most important aspects when it comes to checking your work. I would advise all youngsters that once you have done a document, you have proofread it, leave it be for some time, and probably take a break from the proofreading and do it on the next day, when you can actually understand. You can probably read it with more attention, because if something is repetitive, there is bound to be mistakes.
Right. So we have been talking about what makes it, what are the qualities that makes you a good legal researcher. The next question is something that comes to evident to the next step towards it. So according to you, Sushila ma'am, what are the important factors for a legal researcher to consider when making a decision about the secondary sources or the primary sources? So for instance, if you take a book as a secondary source of law, uh, how can you be sure that this is the right decision to consider a book as a secondary source?
Well, see, there are certain authorities on every subject. Most people are aware of it. If you don't know who are the authorities, make the effort of going and asking. There is no shame in asking it, because we all had to ask. That is how we are here. So if you can find out the authorities, well and good. And I would certainly suggest that people start reading authorities by English authors, although they pertain to the English law, because the concepts have been explained so well that if you understand it once, I think you can never forget it. Thereafter, you can come back to the Indian law and see how the Indian law has developed. So, as far as secondary sources are concerned, always go first for the authorities, and after that, you just keep reading the most recent sources and most recent judgments to understand how it has developed.
So, ma'am, do you think that by any chance secondary sources do they does it help or does it not help with unnecessary research? Do you think that taking secondary source as from a book would be unnecessary research, or you're maybe wailing away your time over that?
No, I think it's very important to go to the secondary sources, because understanding the law is not very easy. Everybody, especially when you are at the early stages of your profession, understanding the primary sources may not be so simple. So it is always better to go to secondary sources. I would also advise and guide that never go to just one particular author. Read the same subject matter which has been written by 3 4 authors, so that you understand how they have interpreted the law from their perspectives, and then decide on how you're going to utilize that particular analysis in your legal research.
Right, right. Okay. So, guys, we have already been talking about all these sources and legal research, and some of the very basic to maybe some of the very individualistic questions. But next thing is with your experience. This is something. This is a question that can only be answered with a little bit of experience. So, Sushila, ma'am, what are the essential ingredients that makes legal research a good legal research? What is essential?
Well, essentially, it is you have to take into consideration the doctrinal research, which is actually a research into the law, the legal rules, the principles, the concepts, the doctrines. Thereafter, you have to do research on these aspects of your doctrinal research, and after that, you have to make an empirical assessment of how the research is affecting or impacting the doctrine, or I would say the primary sources of the law. And also, you should try and see how practical aspects of the law affect these particular aspects that you're researching on. When I say practical aspects, I mean judgments which talk about different fact situations. So when law is interpreted, there is something called being subjective. So the law would apply to different facts differently. The law may remain the same, but the facts would determine as to how the law would apply.
Right. Okay. So, Sushila ma'am, we've been talking about all this primary source, secondary source, doctrinal research, and all that. So, can you tell everybody a little bit about how to actually get the analysis out of all this? We are talking about a lot of case studies, citations, etc. What is analysis that comes out of all this, and how can you get this up, into notice?
Well, nowadays I have been told that one of the tools for researching is something called empirical research, which is a study through direct methods rather than secondary sources, in which you apply day-to-day experiences or day-to-day understanding of the law with vis-a-vis reference to, say, society, the economy, politics, etc. So I think this is a very broad way of doing research, and I think this is a new way which will probably help you to analyze law better.
Right. So we were just talking about, I don't know if you had already known about it, but we were just talking about empirical research, right? You had just given us an idea, a beginning to empirical research. Our next question is that is a continuation of your answer. So, what is the importance of empirical research in the development of law and legal system, according to you? Why has this become so trendy all of a sudden to work on something called empirical research?
Well, it's a new method, isn't it? So it has become trending. Now it's a social legal approach to research. So that's the reason if something new is introduced, it's always trending. And well, so is this.
Okay, so can you push light a little bit more about why is it important to utilize empirical research in today's professional legal scenario?
Well, I would say that it is a more a practical way of handling the situation today. You look at case laws, you look at the subject matter of cases which are current, and you try and analyze the facts, and then see how the law has been interpreted in that fact scenario.
Right. Yes. So again, we have been. So I would like to state out to all the students that we have been talking about, legal research and all the ingredients. But one thing is, very important, which comes out with the next question, is to how to formulate a legal research question, and what are the important considerations. What is the process involved? So you guys have to understand that there is always an issue in hand. There is a question, and then there comes a problem statement, and hence you have to, as legal professionals, find out a mitigation or a contingency plan with it. So what do you so ma'am, how do you think that legal researchers can formulate the right issue with the right circumstances in mind?
Well, like I had said in the beginning, you have to be a master of facts. It is only if you know your facts thoroughly that you will be able to formulate a legal research plan. If you're not clear about your facts, you will always be meandering. So I am consistent on that. That first you should be very clear on your facts. You should not only read your documents once, but maybe a second time, a third time, to understand the document in totality. And once you have identified what are the issues that are involved in that particular scenario, then you should formulate the issues. And once you have formulated the issues, you should also, of course, by formulating the issues, you should also see the end result. That is, what is it that the client has approached you for? And after that, you can make your formulate the way you're going to do the research.
Right. So we have some of the questions. Rashi, we are going to be answering your questions in the Q&A session. Please don't worry about it. But yes, there is a very basic question, that every student wants to know the answer to. So according to you, so somebody keeps on asking, how do I improve my legal writing to make it more accurate and logical, especially in research-based memos and projects?
There is only one way to improve your legal writing, and that is by reading. And reading commentaries written by authors who have a very good command of the English language. If your command on the English language is good, your drafting is bound to be good, because you will learn the ropes by and by. But the basic quality that is required for any drafting is good communication skills, that is good written communication skills. And I have always stressed on this aspect, that people who are not well read must read, and must read different types of books other than just law books. They must also try to improve their language by reading leading newspapers and magazines in which you have well articulated articles. Because without having a command on your language, there is no way that you can improve your writing capabilities. Apart from that, you must also have a structure when you are writing. You must understand that when you are handling any particular legal research, you must look at it like as if you were looking at a person standing, that is from the head till the foot. So plan it out in such a manner that it is done like the first aspect of the research should be an introductory one. Thereafter, you come to the facts. Then you come to the issues or how you have analyzed it. And only after that, you can come to your conclusion. So it must be in a very logical manner. Law is something that has to always be practiced with a lot of logic in mind.
Right. So yes, with the question in mind that what can actually work when it comes to improving legal writing, the next question is something that is a little individualistic and may come with a little bit of experience. With your kind of experience in the industry, what do you think is which method of application is truly missing in the legal industry? Research according to you today.
Well, I won't say missing. I would say that probably with every generation that comes, there is a change in the way they do their work. So while we may have done it very studiously, and while we may have read several books to come to a conclusion, today's generation is very different. I mean, for them, their real guru is just Google, nothing else. So they want quick answers, and they want to do everything online, which is frankly not the way one should do. So that, in my opinion, is a glaring fallacy in your research, because you tend to make it all online or digitalized, and it should not be like that, because at the end of the day, the topics that have been written or discussed online may not be by authorities. Sometimes they are done by very junior people who themselves don't have a grasp on the law. So my advice would be that yes, the new generations must learn to go back to the books, to go back to the library, and that is read the real books rather than read things online.
Exactly. So we totally agree with the fact that working on, so Google can always make a little bit of, everything is brief. There might not be things that might be in a lot of detail, and hence you have to go back to books. At the end of the day, you have to go back to the old, where all the basics, where it all begins. Again, we are talking so much about the methodologies and what is really missing. Ma'am, according to you, what are the legal, so what in legal research, according to you, are uh, the major hacks, best hacks possible? So maybe I might be talking about smart work and not hard work, and legal profession is the smartest profession. According to you, what could be the legal research hacks when it comes to that?
Well, when you say hacks, to be very honest, I don't even understand your language, but I presume you mean tools by which people can actually improve upon their research, right? So, well, the basic tools would obviously mean by reading the head notes of judgments, by reading articles written by leading lawyers or lawyers who have a certain amount of seniority. And it would also be about looking at online reviews of judgments. And I would say these are the legal hacks that you're talking about. And of course, yes, I think these would be the main hacks. Yes.
I think that that's a very relevant, point that you put out. That we generally we might forget, reading the whole book, we might forget to go to the footnotes or the, that the subheadings that are already exist, that subheadings that already exist with it. So you must go back to those. You must go back to the bits that you might be ignoring. Uh, Okay, so the next question is something that is that every legal student might be asking themselves personally in their hearts. What are some common illusions or misconceptions that make students think law school is for them and they will be good at legal research? So this is also for pre-legal, students who might be thinking of going MA in law or maybe beforehand when it comes to just joining in law. So what do you think that are the misconceptions they think about the legal field itself?
Well, you said something very interesting a short while ago. You should act smart, but you should think smart. But law is not about only thinking smart. Law is about working hard. There are no shortcuts in law. You have to read and read and read to understand the basic concepts. So, some of the misconceptions which I feel is misleading people are probably all those serials and the movies which show that law is a very glamorous profession. Believe me, it's not glamorous. It's very tough, but intellectually very stimulating. Another misnomer is that it is very easy to practice. No, law is easy to study while you're doing your law, but very difficult to practice. And another thing is that another misconception which youngsters have is that it is very well paying and it is very easy and you can really be the boss around town and you're a lawyer so you can throw your weight around. Believe me, this does not happen the way you think it does. File any matter in the Supreme Court or in the High Court and see how the registry brings you down to earth. They will point so many mistakes. They will make you feel like a complete fool. So it's not as simple as you think.
Right. And so, Sushila, there's a very, very common, I think, that even a layman might be thinking about when it comes to misconceptions to law. Uh, so, it's okay to cut ethical corners for your clients, especially if they pay a lot. So, what do you think about that statement when it comes to that? And I think that, you yourself might have gone through that question with a lot of your friend circle and family, with when it comes to legal profession, or we watch that in a lot of movies also.
Actually, to be very honest, I don't subscribe to being unethical. I feel that if there is any problem, you can always find a solution. The toughest of problems always have a solution. So work towards that solution rather than take an easy way out. That is not the way to grow. And if you are able to overcome a particular problem by sheer effort, it is going to pay you in the long run. Whereas if you take the easy way out and do something unethical, not only do you risk the chance of being caught, you also lose respect not only in the eyes of others, but also in your own eyes. Because ultimately, being a lawyer is about being smart. And if you were not smart enough to find a solution, then, well, there's not much to say.
Right, exactly. So that was a great insight. We have always, there's a lot of misconception which comes with movies when it comes to legal profession, and I think that you've answered, that question for us today. Okay, so quickly, this is a very quick question. Because the world has turned tech savvy today, everything is technologically driven. What are the tools of research that you would like to, tell the students they might use, or what is your idea about it?
Well, of late, I have noticed that there are many tools for legal research, and I must say they have made researching very, very easy. To begin with, you have all these online libraries, like you have Indian Kanun, you have SCC, you have LexisNexis, you have Manupatra. So these are very good search engines which help you to come to the basic point. But again, I would advise all lawyers not to just go by what the head notes say. One must read the judgment to understand how particular facts have been decided and on what basis has the law been applied.
Right.
Apart from that, of late, I have noticed that there are many digital books and many things are going digitalized. But I think the fun of reading is always in a hard book rather than reading it digitally. Also, let us not forget, you strain your eyes and you get exhausted when you keep reading online.
Yes, right. So, guys, what according to Sushila ma'am is, please go back to the books. Uh, the golden reality of every profession, I think, is that you go back to what really exists there. Books are the most important. They are your friends. They will always be your friends. In this part, as Sushila ma'am, we were discussing, there are, so all the online tools will always help you with legal management, but they would never be able to help you with legal research, legal hardcore research basis. So you can utilize those tools for, I think, as we were discussing, Sushila ma'am, we are talking about all these management tools that are prevalent here today, but they can never, only books can help you. They are your go-to friends when it comes to that. Okay, so Sushila ma'am, here the listed questions are over. We will, Sahil, can we begin with the Q&A? We have some questions in hand. Guys, we would like you, if you have any questions, please post it on the Q&A tab that is present there on your screen. Until then, we can begin with some of the questions asked.
There are many in the chat box too. I think I would advise that you please see the questions.
Yes. So someone is asking how to do research for writing on law articles or a blog.
Well, first, of course, you have to select a topic which would be of relevance. And then, like I said, see how that particular topic has developed over the years. So, if you have, when you are doing legal research, obviously you're going to write on a legal topic. So, see how the legal, how that particular topic has been interpreted earlier. So, do it in a chronological manner. First, understand the concept and then analyze any of the recent judgments, because then your article will be not only very informative, but it will also ensure that you get a number of readers because you have written it in a well-researched manner.
Right. There is another very relevant question asked by Harshita Pandey is which is the best platform for a beginner to start for a district level or from the high level? So where should a legal professional begin with?
Actually, my advice would be that you should begin at the district level. The district level is where the law starts at the district level. So if you are able to practice in a trial court, you understand the ropes of how a matter is decided on facts, which happens only at the district level. After that, the High Court and the Supreme Court is only about questions of law, not of facts. So all youngsters should actually begin at the district courts, spend at least 1 or 2 years in the district courts, learn how cases are decided, and after that you can decide to go anywhere. If your grounding is strong, you will turn out to be a very good professional.
Right. So Harshita, we hope that your question has been answered. There's another very particular question that is asked by Rashi, and she had asked this between the whole conversation. When it comes to finding the maintainability of a particular case, how do we go about this?
Well, when you about the maintainability, well, again, you'll have to see how. Now, suppose a particular matter is not maintainable today, then you will have to go back to your precedents and see when, in a similar fact situation, when such a case has been maintainable, and then you have to understand where you went wrong. So there would obviously be a certain fact scenario when a court is going to entertain it or not entertain it. So do your research properly. There would be cases for the petition and against the petition. Read both, and only after that you start drafting so that you can steer clear of having your case dismissed.
Right. So Rashi, we hope that your question has been answered. There's another very particular question again by Rashi. She asks, when you want to cite a case in your own case, how are we supposed to find case laws or skim the case laws easily because we might not be able to go through the whole judgment?
But that is a very dangerous thing. In fact, I would advise not to do that. I have seen many a times a lawyer is relying on a particular judgment and he has not read the full judgment and he's citing it in court. And before you know it, the other side picks up all those points which are going against him. And before you know it, your entire case comes crumbling down. So do not make the mistake of relying on cases on the basis of head notes. Please, never.
So Rashi, you might have to read the whole judgment and you'll have to go through it all. There is no smart work there. There's only hard work. Okay, so there's...
But Rashi should know that when she chose a profession of being a lawyer, there are no shortcuts. So she has to be ready to do the hard work.
Yes, exactly. She's opting for all. She might she might have wanted an answer out of you. Please make it easy for us. So there is another question from YouTube. Somebody live on YouTube asked this question. Can you highlight the importance of legal research, for instance, change or amendment basis? Whenever there's an amendment, what is the importance of legal research there?
Well, if you have done your legal research thoroughly and properly, and there is a change in law, then you can certainly come up with certain suggestions. If it is at the pre-amendment stage, you can always come up with suggestions. You can always write to the concerned authorities that, look, this is what I have been able to conclude on the basis of all these studies that I have done. You should never underestimate yourself. You never know from whom a good suggestion can come. It can be from a very junior lawyer. It is not necessary that only seniors will come up with good suggestions. So if there is an amendment and you feel that the amendment is hampering the progress of law, discuss it with your seniors. And if you want to raise it at the highest level, what stops you from doing that?
Right. Okay. All right. There is another question, very smart question by Divya. Aditya Jha. So, ma'am, how are we supposed to make our research work get out of the box when it comes to very common research topics like 377?
Very good. It's a very good question. I always feel that people should think out of the box, because when you think out of the box, you are able to analyze law in a very new manner. So you look at what the law says and then think out of the box and question the law. If there are mistakes or if there are aspects which you feel should not be there, why not? Definitely question it and definitely see why there should not be another construction to a particular provision of the law other than what is prevailing.
Okay, so that was a very valid question. Another question that comes here is can you tell us some websites where the judgment cited be able so you can read except the famous Manu Patra, etc. So some other okay. So Ujjwal, we have a whole. So Sushila ma'am has already given us a set of websites or legal tools, management tools that you can look into. What we'll do is we'll put up those for later and take up some maybe other question. Okay, ma'am, according to you, which stream is more daring, being criminal or be it civil? Civil. So, according to you, what is more daring? I think that with criminal cases, students think that you guys are going to get death threats or something. I don't know. Is that true, ma'am?
Yes, it is true. In fact, I personally feel that the as far as practice of law is concerned, the most exciting and most fulfilling type of practice is the criminal law practice. But it is possibly not very easy for everybody to start practicing as a criminal lawyer. But yes, if there is no restriction and if you feel that you can practice as a criminal lawyer, go for it by all means. It is very interesting, and if a topic is very interesting, you are able to give it a good response, and you're able to do a good job.
Okay, so another question that is by Rahul Singh. How important is it for us to go for some certification courses to, advance our research? Do you think that there are some courses that can help us with research? Maybe.
Well, there might be certification courses that help you with your research. To be very honest, I'm not aware of them. But ultimately, if you can get any guidance from any of these research courses, definitely go for it. But the basic will always be the primary and the secondary sources, no matter what course you do.
Okay. So another question. Sometimes a case incorporates more than one statutory, So how to figure out which one may promise a stronger argument?
So again, it would all depend on the facts of the case, right? There are some cases in which the facts don't even match up to the facts of your case, but eventually you look at it from the perspective of the principle, that a principle of law has been set out in those judgments. So you can't decide which part to take or which part not to take. Like I've said, read judgments chronologically. If you want to make the most of your legal research, do it in a chronological fashion. See the leading judgments on the matter and then see how it has developed over the years. Many judgments which are leading judgments are followed, and then subsequently some are overruled. So this is a pattern that you must be aware of, and that's why I say there are no shortcuts in the profession. You have to work hard.
Right. There's another question: is what kind of approach you would suggest for a fresher to get hold of the research and implementing research to his case?
Can you repeat that, Rashi?
Okay. So what kind of approach you would suggest for a fresher to get hold of the research and implementing the research to their case?
Well, I already explained it in the beginning that you have to read your facts very clearly, and it is only after you are a master of your facts that you are able to be a master of the law. So that would be the uh, biggest tool when it comes to your research, that you should master the facts.
Okay, so again, another question they want to ask is how important will it be for us to go for contract and drafting courses during our college journey?
Well, there are two very important aspects to being a lawyer. One is your communication skills in writing, and the other is your communication skills in the spoken word. So, drafting is extremely important because it is drafting that decides the merits of your case, or the merits of a document, or the merits of your opinion. So, taking up a drafting course, I would say, is a good idea. If you can get some specialized training or specialized courses, go for it.
Okay, another question which is I think important when it comes to students. What are the important factors we should focus on while applying for internship?
Well, you should look at a place where you will get an opportunity to really learn rather than just take a certificate and go back home with a certificate. That doesn't make sense because you see, I have been given to understand that getting internships also is not very easy. So you should, when you get a chance, you should definitely make the most and you should be serious about it.
Right. There's another question. Okay, this is something that maybe not just students, every student, not just legal students, are questioning. So when it comes to placement or litigation-based placement, does the tag of NLU really matters, or our hard work gets priority no matters whatever college you choose? So this okay, the evidently Harshita's answered her own question, but yeah, how important is it? When it comes to litigation, why is NLU the go-to place apparently?
Well, we all know that there is a tag as far as NLUs are concerned, but that is not to say that you don't have good students in other colleges. You might have missed the NLU because of sheer bad luck or because there are less seats. But I have learned that you can have a smart lawyer coming from any college. It could be a very ordinary college. So ultimately, in the beginning, maybe where you have passed out from makes a lot of difference. But ultimately, at the end of the day, it is your ability to learn the ropes that will really matter.
Okay, so there is another question that comes is you've already partly answered the question before. Is there any way to limit the research to one aspect and not get lost in it, which covers a wide horizon? A thorough research on one aspect or shallow covering all? What is more important?
Like I said, first you master your facts, make a skeleton of your facts, then see what is the final outcome of your. I mean, if you get any assignment, see what is it that ultimately you want. I mean, are you looking at drafting a case, or are you looking at preparing a transactional document, or are you looking at giving an advice? And accordingly you base your research on the subject matter of your assignment. So you have to look at the brief. Ultimately you have to look at what the client wants, and then so you can't focus. There are times when you can only focus on one particular aspect, but there are times when you have to have a knowledge of different areas of the law. So much would depend on the facts.
Right, exactly. So again, there's another question by Priya Singh, and she's asking. She has second time typed that question. Ma'am, I want to do legal. So I want to do research work on prison reform. Can you give some suggestions how to go about it? The relevant, topics, how to sort that out. So she's working on prison. Ma'am works on corporate, by the way, Priya. But okay, if only if you can help her.
Well, I guess she'll have to approach the prison authorities or see who are the authorities that deal with prison, and then write to them, approach them. If she's already written some article on prisoners, she should send it along with her application so that they know she's serious and she wants to do something commendable, and then take it from there. But as far as suggestions are concerned, I'm afraid I don't really have any suggestions.
Actually, Sushila ma'am has already given you a great suggestion. Is field work is the most important when it comes to a topic like prison research. I think uh, you will have to go there, and hence you will have to find a relevant aspects of what to research about in that. I think that we have especially not a lot of time left, just 6 minutes to go. Okay, there's another question by. Okay, Shaliza Agarwal. So she says, are moods important for understanding real world counterpart of law, and to what extent do these courts set up the match to the real one? The moot court practices she's talking about.
Well, obviously there's a world of difference, but since I have also judged some of the moot court competitions, I must say that there is a huge amount of progress since when we had moot courts. When we were studying law, moot court had just been introduced. So definitely the standard or the bar of moot courts has improved, and it gives you a practical insight, though in a very limited manner, but it prepares you for at least some aspect of what courts would be like.
Right. So it is some aspect, but yes, you can never, I think, imitate reality when it comes to that. All right. I think that we really do not have a lot of time, but okay. So somebody has asked this question: how to make a research paper effective to present in a conference? So whenever you're presenting in a conference, evidently, can you make a joke in the research paper when it comes to legal research?
Why not? To break the ice, you can. See, whenever you are doing any drafting, whether it's a conference paper or it is uh, or or anything for that matter, always put yourself in the other person's shoes who will be listening to you, and try and see what would interest them. If something, if you write a paper in which you miss the point, the main points, and you keep it right for the end of your assignment, you're going to lose the interest. So ultimately, one must always focus on one point, that the attention span of people is very limited. It doesn't matter whether it is in court or whether it is in an interview or whether it's in a conference or whether it's in a moot court. So you should always present your best point first, and if the particular place where you have to do the presentation is not very formal like a court of law, then maybe adding a joke or trying to break the ice or break the gravity of the situation with a joke may not be such a bad idea. It would put everybody at ease, and especially it would put you at ease.
Right. So yes, oration is a big part, and I think that your creativity with the oration, seeing the situation, is the best possible way you can, do good at any conference regarding research papers. I think that we are out of time, guys. We are going to. So some of the questions were already asked. That you guys wanted more details about it. What we're going to do is, Sushila ma'am has already provided us. We are going to put out some pointers for this, and maybe we can send you putting all that together in this whatever we did in the webinar, and we can send you the whole maybe a written document where you can come up, you can see easily, or maybe you can go back to the recorded and you can look into it in more detail. Thank you, Sushila ma'am. Sahil, do we have before we say our goodbyes, do we have any other announcement that you want to make?
Purnima, you can also ask them to email their queries, and we will answer the queries, because I understand that these are young lawyers and they would want correct advice.
Okay, so we'll provide you with the email ID for ma'am, and you can ask the questions, and maybe they can help you with the same. Sahil,
The email ID is theindianlawyer@gmail.com. It's as simple as that. Okay.
all right. Guys, the Indian lawyer at gmail.com. We are also going to post it. Don't worry about that. Sahil,
Okay. Thank you so much, ma'am. It was really an insightful session, and frankly speaking, I loved it. I learned a lot about legal research,
Thank
and
you.
it was really amazing. Thank you, Purnima, for moderating the session today, and it was really good to see the coordination of two such a wonderful ladies having a discussion on legal research. It was really amazing. Thank you so much. And to all the participants who have attended the event, and thank you so much for attending. Just one announcement that we have launched a special counseling connect for you guys, where you can connect with the concerned counselor at Lawyer, and then for your internship, online courses, and any other counseling you require, because you guys are very young and you need some counseling in this particular noble profession for and henceforth. So, in case you have, please feel to contact us. And for we will be putting this recorded session very soon live, where you can put up all your queries, where ma'am would love to answer it. And also, ma'am has provided your email ID, her email ID, where you can reach out to her for any assistance you need. So,
yes,
thank you
we have.
so much.
Thank you, Sushila ma'am. It was great. I think that we are not going to take any more time. But the students, through the counselor, if they want to connect, they would be more than happy to connect. Maybe not directly by one hand to Sushila ma'am, but you can easily take some time up, maybe from some of the associate if you want to. And then we can figure out via email how we can do anything needful for you guys. Thank you. Everybody saying it was really insightful, and thank you so much. All the panelists, there's a lot of people who are saying that. So thank you, ma'am. Thank you so much.
Thank you,
We,
Purnima. And I'm glad that you moderated the entire event. You did a very good job, and we'll leave it at that. Thank you. God bless you.